Welcome to the March 2026 Key Employment Cases Review, sponsored by Veritas Workplace Investigation. Once again, I am Javier Rivera Carbone, employment attorney, workplace investigator. I'm your co-host with George Bean, employment attorney, workplace investigator. George, welcome.
Good afternoon.
We're going to discuss a couple of cases today, George, and I suggest we go by the list that you prepared. Thank you for preparing the list and summaries of the cases. And the first case, if I say it correctly, I'm going to say is Ehrenkranz versus the San Francisco Zen Center.
Yes, this is a case about the ministerial exception, which is interesting. Here, some brief background facts. The plaintiff worked for the San Francisco Zen Center, which was a nonprofit religious corporation, filed wage claims with the labor commissioner, and the labor commissioner found for the employee. The employers appealed to the Superior Court, moving for summary judgment, which the trial court granted. So now we're up at the Court of Appeal, and the Court of Appeal reversed. So, some quick background, the plaintiff was a work apprentice. In order to become a full-time staff member, you have to start as an apprentice. So his tasks included cleaning, preparing guest rooms, chopping wood, mowing the lawn, preparing food for the guests, among other things, including providing childcare for some of the senior staff members. So in the past, courts had found the ministerial exception barred a minister's wage claims against any church. Here, the plaintiff doesn't deny being a minister, or at least a minister in training, for the purpose of the exception, but he questioned whether that exception includes wage claims. The Court of Appeal found that the wage claims did not raise an ecclesiastical concern and therefore were not barred by the exception. So courts are drawing an interesting line here, where even when the parties admit that this is a church, they admit that the person at issue is in the position of a minister, but they're doing some things maybe that are ministerial and some things that are not. And here in particular, the way these apprentice positions worked is they had to do quite a bit of labor before they were qualified to move up to a full-blown staff member. And so these were considered commercial activities, meaning the Zen Center welcomed guests who paid for their rooms. And so those rooms were prepared for, cleaned by people like plaintiffs. So there was a separation between, was I hosting a meditation hour or am I cleaning the toilet? And so the courts have found that we're going to draw a line here. The ministerial exception is not across the board. We're going to look at wage and hour claims and whether those activities were commercially beneficial to the employer and whether they related to the ministerial activity or not. Comments, Javier?
George, I think this is a good one. Because the basic rule is that if you work for a religious organization, as an employee of the religious organization, most of the laws don't even apply to you as an employee.
Right.
And that's the rule, right? Now, this is not only on wage and hour cases, which like this one, in discrimination cases also. But going back to the wage and hour issues, it makes sense that for a religious organization to have people that work for free. But in this case, the trial court went along with the basic rule, and the Court of Appeal essentially said no so fast because of what you said. There were commercial aspects of it. The organization was making money, presumably profit, of the labor of these ministers. So you can be a minister for some things, but you can be an employee for others. The closer the work is to, in my opinion, making money and profit, the more it's going to be commercial, the more it's going to be subject to wage and hour laws. Then that leaves an open question as to what is still part of the job of a minister. So I think this is not going to end. This is just the beginning of a debate. So this is a good one and an important case for religious organizations to be more aligned to businesses if they operate like businesses, or to be more aligned to other religious organizations, and then operate clearly within what ministers are supposed to do. But honestly, after looking at the case, I don't think it's clear. What do you think?
It reminds me of the case we had last month where the Salvation Army was employing people in recovery. And some of the activity could be considered recovery activity, but other times they were doing the same work that paid employees were doing with regard to collecting donations and working in their stores, which were for-profit stores, even though it's a nonprofit organization. So it seems the courts are starting to get pretty consistent about um, volunteers being taken advantage of.
I agree, but although it's called the Salvation Army, it's not a religious organization. So
Nonprofit.
this presumption did not apply to them.
Right. And I was just drawing the connection between volunteers for a nonprofit and part of the religious exemption is they have to be a nonprofit as well.
So it seems that in this presentation, there is consensus between you and I that volunteers, people that work for free, at a private company like the Salvation Army or a religious organization like the Zen Center, the closer it is to a commercial activity for profit, the closer you're going to be subject to wage and hour laws, the more it's related to faith. In the case of the Zen Center, the more it's related to actual volunteering job that people want to do it just because they want to do it for free,
Right.
with no limitations or control, then the closer it will be to no wage and hour laws. So we have some consensus. That's a good thing. Let's see if we're going to have consensus on the next one, George. The next one, I'm going to read it as Guardian Storage Centers, LLC v. Simpson. What say you, George?
Again, super interesting case and very relevant. It brings up issues that I've been seeing in my practice as well, and I'll mention those as I go along. In this case, the plaintiff Simpson was an executive officer for Guardian. During her employment, she forwarded 25 emails to her personal email address, some of which were attorney-client privileged emails. And being an executive, it made sense that she was on that email thread or chain. And so after she was terminated and then sued the company, she turned those emails, amongst others, to her attorneys, her plaintiff's attorney. She turned over about 25 emails, and there were three in question that involved attorney-client privilege. The other 25 may have been confidential, but these three in particular had the attorney on the email, and it discussed things that were legally relevant. So during discovery, her attorneys revealed it. They said, yep, we've got these emails, and we're going to use them. We're going to use them at trial. So Guardian, of course, is very upset. And they moved not only, of course, to probably suppress the emails, but more importantly, to have the attorneys disqualified from the case because they received privileged emails, but didn't comply with the standard ethical obligations that we have as attorneys when we inadvertently receive privileged information from the opposing side. We're supposed to notify the opposing side that we got this information inadvertently, and we're supposed to return them and only examine them to the extent where we discover, oh goodness, these are privileged. We can only read them. We have to stop reading at this point. So the trial court agreed, and everybody found, and everybody was fine with the fact that the disputed emails indeed were privileged. That Guardian, the company, was the privilege holder. So the employees who no longer worked there were not privilege holders. The trial court held that it was significant that Simpson was an intended recipient of the email and that none of the cases cited by Guardian addressed such a circumstance. So we kind of had a situation of first impression. And so the Court of Appeal didn't agree with the trial court that because Simpson was the intended recipient, we didn't have problems. The Court of Appeal said, yes, we do have problems. And attorneys' ethical obligations are still applicable where it was reasonably apparent that the privileged material was taken from the privileged holder, meaning the executive forwarded the email to themselves without authorization. The emails were privileged, there was no waiver, therefore the attorneys were obligated to refrain from examining the materials any more than necessary, immediately notify the privilege holder, and return the document. So the plaintiff received the privileged emails in their capacity of executive, not as individual. When they were no longer working there and were individuals in their individual capacity and then gave privileged material to their attorneys, it was inappropriate. And the attorneys, according to the Court of Appeal, should have, their ethical obligations were then triggered. And so the appellate court remanded it back to the trial court saying, we are finding privilege, we're finding inappropriate. Now, they can't instruct the trial court to disqualify the attorneys because that's the role of the trial court. But the appellate court pretty much said, rethink this the way we're thinking it.
Isn't it too harsh to kick the attorney out of the case? What do you think?
The thinking behind that, and if you read the whole case, they do go into what's the problem here? Why do these rules exist? And one of them is that attorney now has an unfair advantage. That attorney now has knowledge that an attorney should not have, and it could be prejudicial. So the basic considerations of why we don't get to use privileged material are what at play here.
And so you think it is okay? The attorney kind of asked for it by insisting on using something that they shouldn't have looked at, and the Court of Appeal made it seems like it was obvious and evident that you shouldn't have looked at it, and just by standing on it, you were asking to be kicked out of the case, right? That's my read of the case.
Not only that, they were very brazen, saying, not only we're not going to give these back, not only did we do nothing wrong, we're going to use these at trial
as evidence to prove
my
the
case,
contents.
to the retaliation case. And part of the reason I picked this case for presentation is that it's something that I'm seeing more in my practice, which is clients who forward emails to themselves while still working there. And then they have those, and often employees sign confidentiality agreements, and they shouldn't be forwarding emails to themselves and then using them in litigation. Now, that applies to emails that are not even necessarily privileged. They're just company property. And so it's an issue, and you've seen this in cases as well, where a company will countersue for a breach of a confidentiality agreement, gaining leverage over the employee in a matter that's kind of not related to the case itself.
I think, Joshua, let me say two things. First, I agree with the holding of the Court of Appeals. Mm-hmm. I believe that these attorneys were asking to be kicked out of the case. And I agree also that the attorney-client privilege is very powerful as a matter of public policy. And it is so powerful that the only person that can give it up is the owner of the privilege. Having said that, my second comment is that the public policy of the state of California is to make it illegal for employers to retaliate, punish people, or other types of illegal conduct. And for an employee who's working and being witness to illegal conduct, allegedly, well, it makes sense for them to gather evidence to prove their case. In case they're retaliated against, they need evidence to prove it. In case they're witnesses to illegal conduct, to be whistleblowers. In the case that they have evidence of illegal conduct to win their case or represent others, it kind of makes sense and it seems fair for employees to gather evidence. So this is not going to end here, I think, because on the one hand, California is telling people, if you see something, say something, and people want to bring the receipts, so to speak, the receipts, but then can they do that? At the same time, it's telling the attorneys that the attorneys have to be careful. So I think something that I believe is not in the opinion, that there is a duty now for plaintiffs' attorneys to ask their employees, to their clients, that if they're going to share information that belong to the company or used to belong to the company, to make sure that there's nothing privileged there. And for attorneys, that if they see something that remotely is adjacent to attorney-client privilege, they should disclose it to the other side. And maybe the outcome would have been different. George, what do you think? If these attorneys would have said, like, hey, my client sent me a bunch of things, and when I'm looking at it, oh boy, let me give it back. I shouldn't be even looking at this. You think the result would have been different?
Absolutely, it would have been different. There's a set of 2 or 3 things that you have to do when you receive privileged information by accident. The court says those are the same things that that these attorneys should have done. Although the situation is different and they recognize it, still those ethical obligations don't change. And I think you're right. This is going to continue to be an issue. In addition to the fact that more people are remote working since COVID, more people have their own computers at home or their laptop or their phone where they have technically company-owned work-related emails in their own personal possession. So they don't even sometimes have to forward their work email to their personal email be walking around with possession of company property. The line is going to be awful blurry.
No doubt, no doubt. Now, we're not going to say which firm it was, but Now, moving on the case, we have too much consensus this month, George. We
We'll
agree
fight
on the
next month.
result.
We'll fight next month.
All right, let me try for the last case we're going to cover today. I say this Sorokunov v. NetApp Inc. Now, this is an interesting case to me. What happened in this case, just summarizing what happened, is that there was a plaintiff who filed a claim under the special law PAGA, the Private Attorney General Act, that allows for an employee to represent the employee himself or herself and all other employees who are aggrieved or affected by the violations of the employer to make a claim in court for the penalties that the state of California would have recovered from the employer for the violations alleged. That's the basic PAGA notion. And the reason why I took some time to explain that is because I, as a plaintiff individual, I'm going to sit on the shoes of the state of California to make a claim against the employer for the penalties only of all of the employees who were affected by the illegal conduct or violations to the labor code of the employer. Now, there are very many cases, and we can summarize them in this way, that if there is a valid arbitration agreement between the employer and the employee, then the employee loses the authority or power to go to court and make that claim on behalf of the employee and on behalf of the state of California, and the employee is forced to arbitration for the claim of the employee or plaintiff to be tried or handled in arbitration. But the PAGA part of it, on behalf of the state of California, kind of remains in a limbo that may come back to court or may continue in court. And there are some cases from the Court of Appeal that suggest that even if the employee is forced to arbitration, the other claim, the one that I said it was in limbo, may continue in some cases in court, even if the employee is in arbitration. And that's what people are calling the headless PAGA claims, because they don't have a head. The head went to arbitration, the rest of the body stayed in court. Can they do that? We don't know, because the courts of appeals are split, and the California Supreme Court is going to tell us soon, hopefully soon, whether those cases can continue. But this is the other side of that, George, because what happened in this case, and as you know, and we were discussing before making the recording today, what happened in this case is that the employees, the employee was sent to arbitration, went to arbitration, and lost the arbitration. The employer won. So now that the head is dead, can the body continue with the case? And what the Court of Appeals said is that, well, if you are not an aggrieved employee, if you suffer no violations of the labor code by the employer, you cannot represent the employee, the state of California, or the employees for the penalties, because you don't have a case, you're not aggrieved, you cannot use PAGA. That is very, very powerful, because now all those headless PAGA cases that are in limbo, if the employers win, they can use this to close the rest of the case. And in some cases, this argument adopted by the Court of Appeal in this case can be used to not have a headless PAGA claim and allow for the arbitration to go all the way. So this is, again, PAGA, 22 years on, we're still fighting about it. And I think we're going to be discussing about it for the next 22 years, because the amendments made by the Assembly legislature last year are not minimizing the number of cases. If anything, the cases have increased in the last year. So this is going to continue. This is going to continue. What do you think, George? Consensus, or you disagree?
I disagree a little bit from the plaintiff's point of view. And if I could clone myself and had time, I would argue this. I would argue that you're representing the Attorney General of the state of California, who has the right to impose penalties for violations of the labor code, and that the Attorney General doesn't have the obligation to prove that one person in particular is aggrieved in order to represent the rest of the quote-unquote class. And so I would argue that why should not the headless body stay alive? Because I'm representing the Attorney General, and the Attorney General has the right to impose fines upon a company for labor code violations, regardless of whether one particular person was aggrieved or not. That's the argument I would make. I don't have time to make that argument. I'm not really doing POGA cases anymore, but I see an angle there.
Now, George, so let me push back a little, because that is exactly what we're talking about. If the law, labor code, allows the state attorney general to bring these claims, why would the state allow for a private person to do it? So the wisdom of the assembly and the legislature was to say that if you are aggrieved, then you can represent the state. So as part of the code, it's in the law. We cannot go around that. I'm sorry. You have to be aggrieved to be the private attorney general. You're not the attorney general. If you want to be the attorney general, run for office. By the way, I don't know who's running this year, but I think it's up for grabs.
I understand what the law says, but as a plaintiff's attorney who likes to do fun things, this is at least an angle I would look at. I would make an analogy as to why are we limiting the powers of the attorney general? Even though I know you would argue back, you're not the attorney general. We're limiting the powers of the private attorney general, not the public attorney general. I understand that, but like I've told you before, my favorite thing is when a judge says, "Mr. Bean, I've never seen this before," and so I would push forward.
And I hear you. And it seems that we do agree on the law about what the arbitration agreement means, because that is also hotly debated. Is it possible for somebody who has an arbitration agreement to be forced to take it to arbitration? And the courts have come down, including the United States Supreme Court, but there's people who are still fighting it. So you are in good company. Let me just say that we're in good company. Josh, let us finish today, because we can spend a bunch of time doing this, and I would love to continue doing it. But I think there is another interesting case that came down in March, which is the I'm going to say Pechkis case. So it's Pechkis versus the Trustees of the California State University System, specifically Chico State University. And this is an interesting case, I think, because it deals with a couple of professors that file a claim making the allegation that they were discriminated against by Chico State, that they were harassed at Chico State, that they were retaliated by the university. And the response of the university was to file a special motion that is usually reserved for some cases, but let me just say and define it as a motion to strike the allegations, to say, even if the allegations are true, these allegations should not be considered by the court. And the argument that they made was that even if what they were complaining about, those complaints were not related to illegal conduct, and because they were not related to illegal conduct, there was no employment case. And the Court of Appeal analyzed the claims, analyzed the allegations, and this is before even discovery, right? So this is just looking at the complaint. The trial court said, like, yep, you guys don't have a case, get out of my courtroom, went to the Court of Appeal, and the Court of Appeal analyzed it more closely, and they decided that it is true that some of the complaints made by the professors had to do with matters that are part of the work experience. So if you're complaining about something being unfair, but you cannot tie it to an illegal motivation, if you're complaining about work assignments, but you cannot tie it to some illegal conduct, if you're complaining about something that has to do with schedules, hours, and type of work and how the work is done, if you cannot tie it to some illegal motivation or ill will, then you don't have an employment case. And in that sense, Chico State won part of the case. But the Court of Appeals also found at the level of the lawsuit that there were some allegations that reasonably could have been interpreted as tied to or related to an illegal motivation, tied to or related to conduct to punish or retaliation. And in that sense, part of the case went back to the court, and it will continue. And it seems we're going to hear about it in a couple of years, because with the court splitting hairs this closely, I bet this case is coming back. What do you think?
Yeah, these are sometimes confusing to people because this was, you said it was a motion to strike. It was a special motion to strike, which some people call, or a lot of people call, anti-SLAPP. And so some of the activity arose from protected conduct under CCP 425, and some of it didn't. And so again, we have, like we did with the religious exemption, we have a court splitting hairs where the same person's doing two different things, and some of it qualifies and some of it doesn't. So you're right. We'll be seeing this again.
Now, a private employer, can a private employer also use this tool? Because in here we're dealing with Chico State.
Oh, absolutely. Anti-SLAPP is the activity itself was protected under CCP 425, which could be the litigation privilege or the various items that are protected under anti-SLAPP. So the fact that this happens to be the trustees of California State University is just coincidental. Private individuals can use anti-SLAPP.
And the reason why I asked that question is because SLAPP is the strategic, what is it?
Law against public participation. Thanks
In
for
the
the pop
private,
quiz.
so in the private sector, there could be a public participation, like you said, the fact that you're going to court, right?
It's almost like your lawsuit's trying to censor my free speech. You know, public participation, I think, another word for free speech, or the various participations that the statute covers.
And it is pretty unique, pretty special, but in this case, it was used as a tool pretty effectively because now the case seems to be got it back to the trial court. All right, so that's what we're going to discuss. Any questions, comments, concerns? Anything you want to add, George?
No, I think we're good. We're having some really fun cases. Even the cases we didn't discuss, I found some really interesting stuff. There was a First Amendment case that I was dying to discuss, and
Bring it. So what do you have to say about that?
You pointed out wisely that it's not related to employment, but I'm fascinated with First Amendment cases.
So let's just bring it because it's part of the public interest. So what will we have you say about that case?
We'll hit it real quick. This was BB versus Capistrano Unified School District. First grade student contends that her First Amendment rights were violated, of course, her mom, not the student, when she was punished for drawing a picture. The picture said, "Black Lives Matter, Any Life." First grader gave it to another first grader, an African American. The student's mother saw it and wrote an email to the school principal saying, "She will not tolerate any more messages given to our daughter because of her skin color." The student who drew the picture apologized, said she was coming from a good place, but she was also barred from recess for 2 weeks, so she was punished. And the underlying law is that student speech is protected until it collides with the school's interest in preventing disruption and protecting other students. There's a case called Tinker that lays out those two criteria. So if any of those occur, the school must then balance the protection of the students with the constitutional rights to free speech. The district court found that the drawing was not protected by the First Amendment. However, the Ninth Circuit Court of Appeals overturned the district court's granting of summary judgment, finding that the school has the burden to show that its actions were reasonably taken to protect the safety and well-being of the students, meaning apply the Tinker standard and prove to us why you did it right. The case again was remanded with instructions to apply the Tinker appropriate balancing standard. So we have not heard the end of this one. Hot button issue, Black Lives Matter, Any Life. It can be interpreted many different ways. Certainly the first grade student was coming from hopefully a good place and was maybe even trying to make her African-American schoolmate feel comfortable. As the parents wrote in their letter, their daughter's the only African-American student, either in that class or the entire school. So they're sensitive, of course, to this issue. So super hot button topic, but free speech is, really interesting cases come out of free speech.
So let me ask a follow-up question, because this seems to be a double negative, right? At the district court, the court said the message in the note made by the student was not protected. What do you think? A student that says Black Lives Matter, is that, in your opinion, George? Because, this is how court of appeals work. You have judges making opinions. Do you think that was protected?
Well, you're right that it's a double negative because that the district court actually was granting summary judgment. So the question they were really answering was, is there a triable issue of material fact with regard to whether the school district did something wrong or not? And so they're saying there is no issue of triable fact, that everybody agrees on all the facts. And according to the law, as a matter of law, we have to grant summary judgment. So all the facts being laid on the table, we're saying school district didn't do anything wrong.
Because what the student did was not free speech.
But what they're not judging the student, they're judging the school district. They're judging the school district's reaction. The defendant is the school district. That's what's being judged here. And so the district court is saying there is no issue, there is no material fact at issue, and you're entitled to a judgment as a matter of law that you didn't do anything wrong. You punished the kid for drawing a picture, and that you didn't do anything wrong because whatever, because it was disruptive, because it was inappropriate, because it was whatever. But they didn't use the Tinker standard. That's what the Court of Appeal is saying, is use the Tinker standard, analyze the same facts that we all agree upon, but use the appropriate standard. So we're sending it back to you to use the standard that we're pointing out to you that you did not use.
If I was a justice in the Court of Appeal, I'd say, Mr. Bean, you didn't answer my question.
You're asking me if it was racist or not? I don't know. I don't
know. So this is the objective part of it. Did the district court rule that the note was not protected speech?
The district court ruled that it was First Amendment speech loses its rights when it disrupts. For example,
right.
You can't.
So they assumed that it was not protected.
You can't yell fire in a theater. But again, they're answering the question as to whether the school district appropriately disciplined the child or not.
And this is where I'm going. My take on it, and this is finally we found something to disagree on. My take on it was that the district court essentially held that the note was not protected, and for that reason the school did nothing wrong, no harm, no foul. And the Court of Appeal then, in the typical phrase that I use, no so fast, because you are a government, quasi-government, a school district, you have to prove that the real reason why you were acting is to avoid disruption or other valid reasons in the face of a protected communication, protected by the First Amendment. So that's why I call it the double negative, because the district court said, like, well, you don't have a case because what you did is not protected, and the Court of Appeal said, no, so fast, you have to assume that it is protected, and then you, government, have to prove that this child, literally, has a right to communicate and freedom of speech at school.
Analyze the protection of the speech under the appropriate standard. The government shall make no law. Here we have, I mean, if we sort of peel it back to the First Amendment, the government's not allowed to make a law restricting the freedom of speech, right? And so here we have the government, a school district, enforcing a rule circumscribing speech. So the First Amendment question is on the table. We're talking about speech that has been deemed inappropriate by a school district because they punished the child. And so the Court of Appeal is saying you can only call that speech unprotected and thus punishable if it either causes disruption or hurts other students.
In the second grade.
First grade.
First grade.
A 6-year-old.
Right. So want to take any bets? Let's do a prediction market, because betting, well, it used to be illegal. Now betting is legal. Let's do a prediction market. Do you think, George, this case is coming back?
Which court is it in? That's the only question I have.
Well, it's going back to the district court.
The district court will analyze it under the appropriate standard now that it's been instructed to do so. That's a great question. I think whatever the decision is, it's going to be appealed. I mean, it's the parents that are pushing this, obviously not the 6-year-olds.
Maybe we don't. I'm laughing because it's like maybe it is the 6-year-olds who are driving this case. Well, my prediction is that they're going to settle and move on.
If you read the whole case, it is the parent that that are pushing this case. That's a really great question. Where will it land? I mean, we see so many cases. The question is, who's the judge, right? If something goes in front of the Supreme Court of the United States right now, we have the liberal wing and the conservative wing. If it goes to a certain district court or a certain court, these judges are appointed by politicians. They tend to have tendencies and points of view. I guess that's my answer is who's the judge?
Well, I know, but this is I agree with your analysis that you could make a prediction, but on the First Amendment, there's usually consensus on the First Amendment.
Yeah, we had a recent 8-1 decision on a First Amendment question in the U.S. Supreme Court. That was really super interesting.
And for another day. So maybe we're going to call it the First Amendment addendum to the key employment cases.
Yeah.
George, thank you so much for all of the time you dedicated to bringing the cases. And until next month, we thank you for watching, listening. Click and subscribe. And remember, Veritas Workplace Investigations. Investigations in English and Espanol.